On this side of the law, on that side of the law. Who is right, who is wrong, who is for and who's against the law?
Well, hello everyone, and welcome to another edition of Law Talk. It's the fabulous podcast where common answers to common legal questions are provided by some experienced, and some people might even suggest skilled attorneys. I am Mark, the attorney Judson.
I'm Jonathan, Law Dawg, Fontenot.
From the courtrooms of Calcasieu
To the marshes of Cameron Parish.
This is Law Talk, bringing you common answers to common legal questions. Today's topic is wills.
Before you say legal, I think you should do like Miss Farley. Legal.
Yes, the in quotes legal.
Will the same as last will and testament?
Yes.
Okay.
So everybody asked the most common question: do I need a will?
Does anybody ever put this is my second to last will and testament?
No.
Okay. So because they're like one trumps the other. Do I need a will? I think I know this answer. If you have air in your lungs, maybe that's
yes.
Qualification.
My answer to the question is only those who are going to die one day need a will. Everybody else, they don't have to worry about it. Only those who are going to die
will you don't need a will.
That's right. They're going to be preserved forever. But those who are going to die one day need a will. So what is a will? Well, it is a legal document that spells out your wishes as to how you want your property to go after you are gone, after you have left the earth. You're no longer around to tell us. You're no longer around to sign deeds. You're no longer around to sign acts of donation. So you need to have a will, and here's the big deal. In Louisiana, a will has to be executed exactly as to form. It must have proper language. It must have proper witnesses. It must have a proper attestation clause that very properly says that the decedent appeared before them, that the decedent had mental capacity, and that the witnesses actually saw and heard the decedent say, "This is my last will and testament." It is very, very specific as to form.
So, in other words, it's not where you just take the intent, like if it's a contract and it's not very clear when it was started. You still a judge may still take in mind what you intended. But if the form is wrong, then
intent won't carry the day. Just what the will actually says and how it actually goes down. The will could be invalid if it's not in proper form, in which case intestate succession.
Yeah, you throw out the whole will.
Throw out the whole will.
And you have to do it.
Yeah, everything else, we just need it to be substantially correct. As we like to say, it needs to be between the ditches. But a will has to be precisely correct. It's the only thing just about in Louisiana law. And the reason for that is that it's the most litigated form of document. So therefore, we require specific adherence as to form. So the type of form I've been talking about is a notarial will. Another type of will is called an holographic will. That's where the testator can actually put it in their own handwriting, has to be signed, and it has to be dated, and it has to be completely and totally in the testator's handwriting. And it's still a good idea to go talk to a lawyer, even if you're going to do an holographic will, so the lawyer can give you some suggestions as to what to put into the will. So another thing, the independent executor. Law Dawg, what do you think about the independent executor?
I know that's your gospel. The independent executor means that they can do things without the other heir's permission, don't have to have a hearing. So I happen to know that you always have an independent, not just an executor or executrix, you have an independent executrix appointed.
An independent executor has so much flexibility. It's like being a power of attorney for a deceased person. Remember, powers of attorney are only for the
living,
right? And wills are for the dead. So if your will names an independent executor, that independent executor has authority to manage the estate as he or she sees fit, and can only be challenged if they do something wrong or illegal. So it is a huge convenience to name an independent executor in a will. That is reason number one why you need to have a will, even if you don't own any property, or you own very little property, or you're expecting your property to go to your children in equal portions. The other thing is you can put your funeral plans, you can put arrangements. If you want to be cremated, you can put that in the will. If you want to be buried without cremation, you can put that in the will. If you have minor children, you can set up guardians. We call them tutors in Louisiana. You gotta have a will. It's crazy not to have a will. Only those who are going to die one day need a will.
So you said that you can't sign, you can't sell property from the grave. I tried trying to ask me to do successive ownership. I want my nephew to own it for a while, and after he dies, I wanted to. Can you pull off something like that in a will?
We do not legislate. Now, we can have alternative bequests. You can say that I leave everything to my spouse. However, should my spouse predecease me, then in that event, I want everything to go to my children.
You can't have like consecutive.
No, you can't say I leave everything to my spouse. Then when my spouse dies, I want it to go to my cousin. Then when my cousin dies, I want it to go to, my adulterous mistress. No, you can't do that. You only get to leave it one time.
And this person becomes the owner, and they determine.
Yeah, as long as
you can add. I can suggest.
That's right. And wills just clear up everything, and there's just little opportunity for dispute. And I just cannot say it enough. Everybody should have.
Everybody needs will.
That's going to do it for this edition of Law Talk. We're going to will ourselves out of this one, right?
God willing.
God willing. We appreciate you listening in. If you have further questions, look at the website at the bottom of the screen. Tune in next time for your next edition of Law Talk.